Sir, in last class, we had discussed about the concept which is related to the annual general meeting and which is related to the extraordinary general meeting. That is section 96 we had discussed, and that is section 100 we had discussed. What is annual general meeting? When you can conduct the annual general meeting? Where you can conduct the annual general meeting? If you are a public company, if you are a private company, an extraordinary general meeting, when you can conduct the extraordinary general meeting, where you can conduct the extraordinary general meeting. Okay, so like that, these are the concepts, section 96 and section 100 related concepts were discussed under last class. So today, sir, we are discussed about, okay, sir, we can go for annual general meeting, we can go for extraordinary general meeting, but you wanted to conduct the meeting compulsory, there is a requisitions, there's a requirements of meeting. What are the basic requirements you wanted to constitute a valid general meeting? Out of the all requirements, first of the requirement is nothing but notice. So what is meant by generally what is notice, sir? Suppose any company, sir, either you are a public company or you are a private company, any company they wanted to conduct the meeting, the information is communicated to all shareholders. How they can communicate it, sir? In the form of sending a notice to the all shareholders. So when you can send a notice, sir, law clearly says that according to the Companies Act, section 101 related to the notice. So in this section 101 clearly says that the company can communicate to all shareholders for inviting to attend the general meeting, to participate in the general meeting, to vote in the general meeting. For that purpose, they are communicating, means they are communicating to the all the shareholders through notice. So when they can communicate at least to 21 clear days. Sir, clear days का मतलब क्या है sir? 21 clear days means they are not calculating national holidays. National holidays are not counted. And also, sir, the date of notice, and the date of meeting, So date of notice is excluded and date of meeting is excluded. Between these two, 21 clear days are required. Clear days. Out of that, national holidays are there, then those are excluded. And also, sir, whenever you can send the notice through post, after notice, 48 hours are also excluded. So whenever they can send through post, no, then after date of notice, again you can exclude 48 hours. 48 hours means 2 days. After that, whenever you can send it through post, then again 2 days are excluded. After 2 days, they can calculate 21 clear days. Like that, whenever any company, they can call the meeting, they can call all the shareholders, then they can communicate a notice to each and every shareholder. So these notice, how many days are minimum? 21 clear days are required. Whenever you can calculate the clear days, national holidays are not counted. And whenever you are calculating the clear days, date of meeting and date of notice, these two are excluded. And also, whenever you are sending a notice through post, after date of notice, 48 hours are excluded, then only that is calculated 21 clear days. Sir, and also, sir, this notice is sent to the all the members either in physical form or in electronic form also. Whenever you can send a notice to electronic form, that is called as e-notice. Physical form either per post, okay, so either post or either speed post, registered post, or hand delivery, whatever it may be the mode, either you can physical delivery of notes will notice, or electronic forms are in electronic form, either email you can send notice to the shareholders. Whenever you can send electronic form e-notice, you have to follow some rules and regulations related to the electronic form of notice that can be discussed under rules related section, rules related to the company's management and administration rules 2014. What are those matters? Now we will go through with that. Listen. So listen, one more point before that. So 21 clear days are required whenever you can call for meeting. But this is said less than 21 days also permissible or not permissible. So that is permissible. That is called as a shorter notice. So, but shorter notice is permissible, but it can be approved by the minimum of 95% of shareholders. The minimum of 95% of the people are agreed, then company can go for shorter notice also, but shorter notice also not less than 7 days. Okay, so now go through with that. So listen. So here, section 101, the general meeting of a company. The general meeting of a company may be called by giving not less than 21 clear days, either post or electronic mode. Whenever calculating the clear days, national holidays are excluded. And also, sir, whenever calculating the 21 clear days, date of notice and date of meeting, both are also excluded. And also, whenever you can send a notice through post, after that, 48 hours are also excluded. So, what is the notice consists of? What is the time when you can conduct the general meeting, on which day you are conduct the general meeting, which place you are conduct the general meeting, everything shall be mentioned in the notice. So the notice is given to each and every member, each and every director, and each and every auditor. So notice is communicated to each and every member. So member is died, then the notice is communicated to legal representative, or member become insolvent. Court is appointed one person that is called as official assignee. The notice is communicated to the official assignee. And also, so you can send notice to each and every member, but you are failure to send a notice to one person. Without sending the notice to one person, you can conduct the meeting, you can pass the resolution, you take the decisions. What law clearly says that if there's an accidental omission of sending of notice to a particular person, it will not affect the decisions of meeting. Even though there is no communication to the other party, whatever the decisions are taken, those are a valid decision. So accidental omission in sending notice shall not invalidate the process. Okay, so that is a valid process. Okay, sir. Like the yes, sir, you can send a notice. The notice either may be in a physical form or electronic form. Whenever the electronic form of notice, e-notice, that is called as e-notice. Whenever you can go for e-notice, you should follow Rule 18. Rule 18 of Companies Management Administration Rules 2014. Companies Management and Administration Rules 2014, it will gives what is a procedure related to the electronic form of notice. So e-notice in the sense we are using one software, one computer program or not, then what the program will do. So first one is authorized and secure computer program. So authorized and secure. Whenever whatever the software, whatever the program you are using to send a notice, that is authorized and secure. No one cannot, there is no one is not having any right to hack that one. No one is not having any means control on that particular software. Like that authorized and secure computer program. What this computer program will do, they make a communication to all shareholders. They can send a notice to all shareholders and they can record the acknowledgement. Sir, that notice is sent to their mail ID or not, send or failure, that record, they can maintain such a record. And also, sir, all the information they can be stored at a centralized server system. So these are the three important points whenever authorized and secured computer program. E-notice is nothing but electronic form, sir. Electronic form means you can prepare a notice, the notice sent to their email or not. What this electronic program will do, they can send notice to each and every registered email ID. After sending, as send in or later, or if you send it or not, that can be recorded, recording of acknowledgement, or this all matter can be stored at a centralized server system. And you can send to what, sir? You can send to their registered email IDs. Why? Because every shareholder, they can register their email IDs at a company. Or you are purchasing the shares in depositories. So you are purchasing shares from secondary market stock exchange, no? Whenever you can register stock exchange means you are purchasing from NSDL and CDSL. We're already studied about these are called as depositories in prospectus chapters. We know about that. Whenever you are purchasing shares from a stock exchange, you are registered your email ID at the stock exchange. Then you can send to that particular email IDs. So the company shall send e-notice to registered email IDs of members. Okay, sir. They are not registered their email IDs. How can I send? That is the reason why. If they are registered, then registered email IDs, we can send a notice. If not registered, it's not your liability to send the notice. Then you can send through in physical format like post. Sir, what the subject line, whenever you are sending the notice, the subject line of email comprising of three information. Subject lines, sir. In case of email, you have the subject line. No? The subject line consists of what, sir? Three information. What is the name of the company? What is the type of meeting? What is the time, date, place of the meeting? The subject line consists of that one. And failure in transmission of sending e-notice by a company or receiving the notice by a member shall not invalidate. This is what we have studied also. You are sending, but failure, that is not my mistake, that is not invalidate the proceedings of the general meeting. So here, registered email IDs are there. So meanwhile, you wanted to change the email ID, you give an opportunity to the shareholders, they wanted to upgrade their email IDs, they can upgrade. Company shall notice once in a financial year, provide an opportunity to all members to register their email IDs and to update their email IDs. So how they can company sends a company on their own, in company can appoint one people, some people, they can send a notice. Or company, the sending of notice work can be transferred to the outside agencies. Those are called as, since company can send e-notice to in-house resources or outsourcing agencies also. Agent means company can send notice directly to each and every member, or company, that problem, that information can be transferred to one of the outsourcing agencies. They can send a notice. Like this, nothing but electronic form of notice. Whenever you can discuss about section 101 notice concept, there's a two concept, section 101 plus rule 18 also. Rule 18 of companies management and administration rules 2014. Rule 18 clearly says the word electronic form of notice. Whenever electronic form of notice, you have to remember this small shortcut ARS FUM. What is ARS? A is nothing but authorized secure computer program. What this computer program will do? They can send a communication, they can record the communication and maintain it centralized server system. R is nothing but registered email IDs. We can send to their registered email IDs. Subject line. What is the subject line? What is the type of meeting? When they are conducting? What is the place of the meeting? And everything shall be subject line. Failure in transmission. So no problem, we can failure to send transmission, either accidental omission, then at that point of situation, these are not invalidate the proceedings of the meeting. U is nothing but upgrade. Upgrade in the sense you have to upgrade your email IDs once in a financial year. The company give an opportunity to the shareholder, they can upgrade their email IDs. Last one is mode of transmission. How they can transfer, company can transfer. Company inbuilt, they can appoint some people. They can, that is called as in-house resources. This work can be given to any outsourcing agencies to sending the notice, like there is nothing but mode of transmission. These are all about related to the electronic form of notice. Now I can show one notice that can be received through my email. Listen, sir. Wait. Right, sir. I can show I'm a registered shareholder in one of the company. Then how they can send to my mail ID, how the notice format, what they are mentioning, electronic notice, what is the procedure, same thing is there in the notice or not, I will disclose. Wait. So listen. Yes, we are identifying the BPCL International, BPCL International Limited, notice of AGM and annual report 1920. So it's a BVCL International Limited. CN number, register office, email date. Dear members, this is to inform you that 35th annual general meeting of the BPCL International Limited of a company will held Wednesday, December 30, 2020 at 4 p.m. through video conferencing or audio means. Transact the business set forth in the notice of 35th AGM. The notice and annual report of a company shall be available. This is the notice where it is available. Okay, so you should click on that. BPCL International Limited. Yes, sir, one more thing, one more notice also. So that can be sent to my registered mail ID, and also the subject line they can be mentioned what type of meeting, when they can conduct it, and also another reason. So not a software limited, TDS, sorry, this is TDS related. Once they have issued a dividend to me, then TDS collected. So in here e-voting, they are sending notice to me 27th annual general meeting of members of Oil and Natural Gas Corporation Limited. The subject line of email, sir, what is the name of the company and what is the type of meeting? What is when they are conducting the everything. Since the 27th AGM of member of Oil and Natural Gas Corporation Limited to be held on Friday 9th October 2020. It's a video conferencing. Sir, Polio, client name of the member, Narasimha Rao Modugula. Dear members of notice convening 27th annual general meeting AGM. This is inform you that 27th AGM of member of Oil and Natural Gas Corporation Limited scheduled to be held on 9th October 2020. So like that, so this is the notice. So like that, every company, so ONGC notice is there. One more notice I have. So these are the different type of notices, sir. Now what we have studied here, same thing now, communications, registered email ID, subject line, name of the company, type of meeting, time and date plus they can mention. Failure in transmission, no problem. Upgrade, they can give a chance to me. I wanted to upgrade my email ID. No problem. They can be sent. How they can send, sir? From the company in-house resources they can send, or outsourcing agencies also they can send a notice to me. Like that, they can maintain section 101 notice concept. Then now, sir. Right? Yeah. Here's a listen. Write about notice. Write about notice of a meeting, shorter notice, and contents of the notice. Length of the notice. What is the length, sir? 21 clear days. The notice sent to whom? All the members. All member is dead, legal representative. Member become insolvent, assignee to auditors and directors. You can send a notice in writing or electronic mode, in the physical format or electronic form. So Section 8 company is having an exception. This concept we have studied under Section 8 company also. Generally 21 days clear days, but Section 8 company exception 14 clear days is sufficient. This concept, types of companies, concept Section 8 companies, already you are know about that. Mode of sending a notice. Sir. Sending notices through electronic mode. This said rule text and attachment email as a notification provide electronic link, uniform resource locator. Yes, sir. They can send a text to send yes, sir. One thing they can attach to email, they can attach one notice, they can and they can give a link to one notice. No, oil and BPCL, they can give a link to me. Already shown. So like that they can link or they can give URL, uniform resource locator. The email shall be addressed to the person entitled to receive such email as per the records of the company provided in the depository. And also you can give an opportunity to upgrade your mail once in every finance year. Okay, so if not recorded, then company is not responsible to send a notice. Okay, sir. Nowadays, what happened? Notice shall be placed in the website of a company also. So here, sir, 21 clear days means the date of notice and date of meeting is excluded. Between 21 days is there, and whenever sent through post, again 48 hours are also not counted. The notice shall be sent 21 days before the date of meeting. It quite obvious to question as to what the term clear days means. 21 days means the day on which notice is served and the date of meeting are excluded from the sending of notice. Okay, sir. Sir, what is example here? Go through with example. Mr. Abir filed a complaint against the company, private limited, since they did not serve the notice to him for attending the annual general meeting. The company in turn provided the proof that they had sent the notice by way of email to Mr. Abir, inviting him to attend the annual general meeting of a company. Abir alleges that he never received the mail. State whether the company is liable for guilty. No, sir. Company can send a notice. He is not receiving notice. I am not responsible for that. Clearly, sir, I can send a notice to the registered email ID. The email ID is correct or wrong. I am not responsible for that. As per Rule 18, Companies Management Rules 2014, the company obligation shall be satisfied when it transmit the email, and the company shall not held responsible for failure in transmission beyond its control. The members entitled to receive the notice fails to provide update relevant email address of a company or depository participant. As the case may be, the company shall not be fault. Sir, shorter notice, sir. Generally, general meeting need 21 days. But shorter notice is permissible, yes. But 95% people are agreed. Then shorter notice is permissible. Sir, in case of annual general meeting, by not less than 95% people are entitled to vote, then the shorter notice is permissible. But other than AGM, in case of any other general meeting, where members 95% of paid up share capital, companies having share capital, companies not having share capital, 95% of voting powers, everything is same, sir, no problem. Okay, so 95%. Then is what are the contents in the notice? What you should mention, sir? Date, time, hour, place. What are the matters you going to be discussed under the meeting that can be discussed under that can be mentioned in the notice. Sir, your omission of notice, sir, no problem. What we have studied, sir, omission of notice to a person, it will not invalidate the proceedings of the meeting. Any accidental omission to give a notice or non-receipt of the notice to any member or other person who entitled to receive the notice will not invalidate. Okay, sir. So these rules, whatever the rules are there above here mentioned, no, these are also flexible for private companies. This is the concept related to the notice. Everyone is clear, sir? Everyone is clear, notice? Any doubt? Clear? Okay. So next, sir. What is the next concept which is related to that? There's nothing but section 102. What is section 102? What is section 102? Listen. So what is section 102? That is nothing but explanatory statement and ordinary business. So you can send a notice, sir. In that notice, you are mentioning what are the transactions we are discussed in the meeting. What are the matters we wanted to discuss in the meeting? For what are the matters we are conducting voting in the meeting? Like that, whenever you can send a notice to each and every shareholder, each and every member, each and every director, auditor, or the responsible person, the legal representative, official assignee, the notice consists of on which matter, what is the purpose to conduct the annual general meeting. So generally, sir, annual general meeting, they are discussed about only ordinary matters. They are discussed about only ordinary matters, sir. What are the ordinary matters? Sir, one is a declaration of dividend or adoption of financial statements, appointment of auditor and removal of auditor, appointment of director and removal of director. So these are the four ordinary businesses in every annual general meeting. We can go with these four ordinary meetings only. So annual general meeting is meant for only these four ordinary purposes. Yes, so these four ordinary purposes only we will conduct annual general meeting. Other than any purpose, we cannot conduct annual general meeting. These are called as ordinary businesses. AGM is meant for only ordinary business. Not only the only ordinary, sir, even extraordinary business also you can mention. So these are all ordinary, sir. Generally, we are doing these businesses in every AGM. Not only these activities, we can do extraordinary, other than ordinary businesses also, we will conduct in the annual general meeting. Whenever we are conducting the other than ordinary business, those are extraordinary businesses, those are special businesses. Whenever you are conducting special businesses, we should give an explanatory statement to that. There is nothing but explanatory statement. So what the matter we are doing, what are the related situations, what we are discussing related to that, who is having the interest, the director is having interest, promoter is having interest, key managerial person is having interest, the people who are having any financial interest in that, any other interest is there, everything shall be mentioned in that particular explanatory statement that can be filed to the registrar. So in that particular decision, sir, whenever you are taking a decision, other than ordinary business, we are doing some businesses, some decisions. In that particular decision, your company director, your company key managerial person, your company, okay, so promoter, your company manager is having any interest. Or in that particular decisions, your company, you are having 2% of paid up share capital of a company. Okay, so in other company in which we are in other companies, so the business transactions which is related to the other company, in that particular other company, your director, promoter, key manager person is having at least 2% or more paid up share capital. Okay, so that matters are there. That matters you can prepare an explanatory statement that can be attached to the notice. The same thing is communicated to all shareholders. So these are called as special businesses. And special businesses require explanatory statement. Ordinary businesses not require explanatory statement, which is business special business. There's an ordinary business where you can mention, sir, AGM only we can mention ordinary business. But special businesses where you can mention, sir, special business either in AGM or extraordinary general meeting also we can conduct special business. But annual general, but in extraordinary general meeting, in extraordinary AGM may, ordinary businesses we cannot conduct. Ordinary businesses always you should conduct in AGM, but special business either you can conduct in the AGM or either you can conduct in the EGM. Everything is permissible. So listen, sir, what is ordinary business? So ordinary business shall be transacted in AGM only. Ordinary business is called as ordinary because 21 clear days notice AGM shall not state the words ordinary business. They cannot mention the ordinary business. Even though they are not mentioned ordinary business, these four activities they can do. What is that? Consideration of accounts. That is nothing but adoption of financial statements. Declaration of dividend, appointment and removal of a director, and appointment removal of auditor. These are all ordinary businesses. Ordinary businesses only it can be done at AGM. Ordinary businesses can be done only in AGM only, not any extraordinary general meeting. But other than ordinary, it is called as special business. Whenever you are doing special business, because of such special business, your manager, your director, your key managerial person, your promoter is having any advantage, any benefit, or advantages to the other company. In that other company, your director, manager, key manager person is having any interest, then you can give an explanatory statement to answer. Special business can be transacted both AGM and AGM. Everything other than ordinary is called as special business. In the 21 clear days notice, whenever you can go with the special business, you can give an explanatory statement. When, sir, when explanatory statement is given, sir, you are having any interest, either your promoter, your director, your manager, your key manager person, or their relative, they are having any interest in that, or in that the matter which is related to the other company, but in the other company, more than 2% of paid up share capital held by your promoter, director, key manager person, at that point of situation, you should mention explanatory statement. That is all about section 102, ordinary businesses and explanatory statement. Incomplete disclosure, concealment of material facts. Compulsory should disclose it now. Whatever the interest you have, whatever the benefit you receive can be. So if you not disclose, then there is a penalty. What is the penalty, sir? Minimum 50,000 rupees, maximum 5 times of the benefit received, whichever is high. This is the concept which is related to the ordinary business and explanatory statement. Then what is there in our material? Explanatory statement. Go through with that. Section 102 of Companies Act 2013 mentions that a special business will be transacted at a company general meeting and it requires explanatory statement. So in that explanatory statement, whenever there is interest, financial interest, either held by director, key manager person, relative, it can be disclosed. Generally, business is two types. One is ordinary businesses and special business. These four are called as ordinary business. Consideration of financial account statements, reports, declaration of dividend, appointment, removal of auditor, appointment, removal of director. These are all our ordinary businesses. For ordinary businesses can be done in only AGM. But extraordinary special businesses, both AGM and EGM. So whenever the 2% shareholding in any other company, then explanatory statement is required. Where an item of special business which is transacted at meeting of a company relates to or affect any other company in which 2% or more shares held by one director, promoter, like that, at that point of situation also, we should mention explanatory statement. So if not disclosed, compulsory should disclose. So if you are not disclosed that explanatory statement, then at that point of situation, there is a penalty minimum of 50,000 rupees, maximum 5 times, whichever is high. Clear, sir? This is all about section 102 related to the ordinary businesses and explanatory statement.